Hello, this is talk 2 on the series of talks about discrimination and unlawful acts under the Equality Act 2010. This talk deals with indirect discrimination and has been prepared by myself, Declan O'Dempsey, and Catherine Casserly, barristers at Cloisters Chambers. Indirect discrimination under Section 19 occurs where the respondent applies or would apply an apparently neutral provision, criterion or practice, you'll hear these referred to as PCPs, which puts the workers sharing a protected characteristic at a particular disadvantage. So it's got to be applied to everyone within the relevant group, including the claimant, and the PCP must put, or it would put, people who share the claimant's protected characteristic at a particular disadvantage when compared with people who don't have that characteristic. It's the PCP which must put, or would put, the claimant at that disadvantage. So in other words, as well as group disadvantage, there has to be individual disadvantage. And then finally, the respondent must be unable to show that the PCP is a proportionate means of achieving a legitimate aim. As with direct discrimination, intention is irrelevant. So what is a PCP, or provision, criterion or practice? You have to construe this concept widely, and it's going to include any formal or informal policies, rules, practices, arrangements, criteria, conditions, prerequisites, qualifications or provisions. But it can also include decisions to do something in the future, such as criteria that hasn't been applied yet. And it will also include one-off or discretionary decisions. So the idea of indirect discrimination is that it should apply to PCPs which have not yet been applied, but which would have a discriminatory effect if they were applied, as well as applying to those which actually have been applied. What is a particular disadvantage? It's something that stretches from things which inherently disadvantage a group to something where you can show by means, for example, of statistics, that this particular protected characteristic group is disadvantaged. So it stems from the obvious to the ones where you're going to need to prove carefully the disadvantage by means of a statistical analysis. But disadvantage includes denial of an opportunity or choice, deterrence, rejection or exclusion. It's going to be something which a reasonable person would complain about, so an unjustified sense of grievance is insufficient. However, if the claimant can reasonably say that they would have preferred to have been treated differently, then that will be enough to demonstrate disadvantage. As with direct discrimination, you have to conduct a comparative exercise. The PCP is capable of being intrinsically liable to disadvantage a group with a particular characteristic, so that statistics are not always necessary. However, in most cases, you'll have to make the comparison, and the circumstances of the two groups you pick must be sufficiently similar for a comparison to be made, and there must be no material differences in the circumstances. So what are you comparing? You're comparing the situation of the impact of the PCP on people without the relevant protected characteristic and its impact on people with the relevant protected characteristic. I said earlier that it's also got to have an individual disadvantaging effect, but that effect has to be the same effect as it has on the group. Obviously, it also applies, indirect discrimination also applies where it's capable of having the effect on the individual. So it's not enough for the claimant to establish that they are a member of the relevant protected characteristic group. They've also got to show that they've suffered personally or could suffer the particular disadvantage as an individual. Indirect discrimination can be justified, and Section 19(2)(d) of the Act makes provision for this. The burden of proof shifts from the claimant to the respondent to show that the PCP is a proportionate means, so that means an appropriate and necessary means of achieving a legitimate aim. Legitimate aims in the context of indirect discrimination are not defined, and they can be purely private reasons of the employer. Cost saving alone will not be a legitimate aim. The aim should not be discriminatory in itself, and it must also represent a real and objective consideration. So in comparison with age discrimination justification of direct discrimination, the aims in this context of indirect discrimination can be purely private reasons of the employer. In the case of direct age discrimination justification, they have to have a public interest nature to them. From the claimant's point of view, it's important to see whether or not you can separate the aims from the means. So having an aim of having 24/7 production mixes up the aim of being more profitable or more efficient with the means having 24/7 shifts. The other area that the claimant can challenge is whether the aim has so great a discriminatory effect that it's not legitimate, or if there's some other illegality involved in it. Now, although the burden is on the employer, the claimant can raise the true aim, and you may want to do that if what you want to say is that in relation to the real aim, the means adopted were not proportionate. Proportionate means. The means have to be appropriate to achieve the aim and reasonably necessary to achieve it. And at the minimum, the Employment Tribunal has to engage in a critical evaluation of whether the respondent's reasons demonstrate a real need to impose the disadvantage. If that need is proved, the Tribunal considers the seriousness of the disparate impact on the protected characteristic group, including the claimant. And then finally, the Tribunal must evaluate whether the former was sufficient to outweigh the latter. So the need, is it sufficiently important to outweigh the discriminatory impact? The Employment Code at 4.31 deals with proportionate means. If it's an appropriate and necessary means of achieving a legitimate aim, the PCP may be justified. But necessary here doesn't mean that the PCP is the only possible way of achieving the aim. It will be enough if the same aim could not be achieved by less discriminatory means. So what this evaluation requires a tribunal to do is to make judgments upon systems of work, feasibility or otherwise, the practical problems which may or may not arise in a particular business, and the economic impact in a competitive world which the restrictions impose on the employer's freedom of action. And that requires the tribunal to spend time over this. So it requires the claimant to spend a bit of time ensuring that the tribunal looks into it properly.